What up? What up? What up? Hey, young jerks. Good to be back. I wasn't sure I was going to do a show tonight, but everyone was asking for it. And I just hit up Mark. I said, Mark, what do you think? You have any time tonight? He said 8 p.m. I said, I'm there. Let's do it. And then Aiden broke some news. So we have a lot to talk about. Aiden's case, as well as what happened in court today with Karen and the civil case, and some new people that may be attached to that. We'll see. Let's bring him up. Attorney Mark Bederow is here. He's all dressed up, fancy today. I think he had court. I'm kind of bumming it. Look at, I don't have the suit jacket. I got the hoodie. He's got the nice jacket. Look at him tonight.
Every now and then you have to dress like a lawyer. It's not by choice, but you got to do it. Sometimes.
Got to do it. And you have a big court date coming up on Wednesday, right? This week?
Wednesday, 2:00, Norfolk Superior Court. Sure. I'll be there.
Are you going to be there for that, or are you going to be zooming it? Like, what's going on that?
No, I'll be there. I'm heading in tomorrow. I'll be there.
Oh boy, travel day tomorrow. So we got you right before you're traveling. What people are already asking, what's going on with Aiden? He just made an announcement. I didn't read the full announcement. He was kind of teasing it, but then I guess he did make the announcement. What's going on? What is this announcement that's good news for Aiden tonight?
Well, if it's in the public record, it's in the public record. I mean, I think people are familiar based on recent filings, as well as whatever was reported tonight, that an alleged victim in a case sued the prosecutor and the lead detective, and then sent a demand letter to the district attorney indicating her intent to sue the office for the alleged intentional misconduct of the special prosecutor and lead detective, which creates all kinds of irreconcilable conflicts all over the place. So, I mean, anybody who does this for a living and knows how this works would have understood that as soon as that lawsuit was filed against the prosecutor and lead detective, that the prosecutor would be gone from that case within a matter of days. It's just a matter of thinking it through and coming to the conclusion. She's alleging that he did things intentionally to wrong her. And let me first state, I don't think that's true. I think Mr. Cosgrove is an honest man. We have some issues that you might have seen in the filing with some things that have happened in the case. But as it relates to him personally, I think, he's not that. And the bottom line is, though, if he's been accused of something, his interests are entirely at odds with the person accusing him, right? And he can't prosecute a case at the same time that he agrees that with us that the witness is not credible. And he can't make representations that, she may challenge. So it's not surprising. You know that Mello was thrown off that case at our request. That was our request from a year ago, finally. And then there was another prosecutor in that case, a guy named Novak, who was involved, who apparently the day after we filed the motion submitted his own withdrawal motion to get out of the case that he filed with court. So as it stands right now, assuming these motions are granted, meaning Mr. Cosgrove and Novak to withdraw, and they have to be granted. They have a conflict. There's no argument here. No one's going to oppose this. There's no basis to oppose it. Then all three special prosecutors, not even DA employees, who cost taxpayers extra money on top of the DAs who get salary, they had to pay three prosecutors out of additional taxpayer funds, have all either sought to withdraw or been kicked off for either making themselves witnesses or having a conflict. And the reality is, by Wednesday, what's the sum total of this? The case is basically stateless. There's no prosecutor. There is literally, as of Wednesday, will not be a prosecutor on that indictment, the 2024 indictments. That doesn't affect the other ones. But so there'll have to be a tough decision to make about whether somebody can substitute in or be hired. But the problem with that is, in light of the demand letter that was sent to Michael Morrissey threatening to sue him, that creates an irreconcilable conflict for the DA to assign a prosecutor, because there could be an appearance that he hires somebody out of his own self-interest to, protect him in the office from the person suing him as much as anyone else. So, this is a fiasco, but it's all of their own doing. And I mean, let's be honest, none of this is surprising to me. But, this is the case that led him to go to jail. Don't forget that. This is the indictment that led him to go to jail, in which we have alleged in public filings was created by a bunch of people getting together and coming up with this idea. And, we'll leave it at that. That's what's in the public record. We'll see where it goes. But as it stands right now, as of Wednesday, they'll just simply have no prosecutors on this case.
Unbelievable. Have you ever been involved in a defense where this happens, where there's no prosecutor left?
No. I mean, we've seen requests for special prosecutors. I've had cases where, the Brooklyn DA has a conflict because they know a witness committed perjury. So can you refer it to the Staten Island DA, that kind of thing. But it's very rare to see, like you see in Norfolk County, the frequency with which they use special prosecutors again and again at taxpayer expense. If you go to another county prosecutor, you're not wasting more taxpayer money. But these are handpicked people by the DA, okay, at extensive taxpayer and additional taxpayer expense, who are getting thrown off these cases for making themselves witnesses, for having conflicts of interest. And you just have to ask yourself, does any of this have any credibility? And, why? I mean, this is just a fiasco. And if your question is, have I ever seen anything like this? Of course not. Nobody has.
Yeah, not even Bederow's seen it. I mean, that's. I mean, you've seen a lot. Because I read the little.
I've never seen this.
You've never seen this, though.
I've seen a lot. I have never seen a complaining witness on an open set of criminal indictments sue a special prosecutor, a lead detective, as a counterclaim to the defendant who sued her for defamation, and then follow that up by essentially sending a demand letter threatening to sue the DA's office. No, I've never seen that, and I don't expect I ever will again.
It was like the best thing ever. It's full funny because they thought it was gonna I don't see how they thought this would help. I just don't. I mean, I don't even expect you to answer that one, because we just know who's behind this, and it's just so funny. It's just like, what are you thinking? It's funny.
I don't know what to say other than what's the public record. It's unique.
It is unique. Someone else brought it up, and you kind of mentioned it. It's only going to affect the Lindsay cases. Cosgrove's only resigned on the Lindsay G case, not in Turtle Boy other cases, but it could actually help. I have a feeling it is the same. What do you think? Will it help the other cases too, maybe, possibly?
That's not what I said. I said, for the moment, it only affects the 2024 indictments. Do not assume it does not affect the 2023 indictments. That's an issue that will be dealt with in a future time, but there are all kinds of potential overlaps with evidence that could implicate, if a witness were to accuse a lead detective of doing things with a cell phone, for example, and there could be data on that cell phone that is extraordinarily relevant to a different case, 2023 indictment, you should not assume that it's a clean issue as it relates to that case. What I said was, right now it affects the 2024 case. That's the application made by the prosecutors, but that issue is long from finished as it relates to the other cases.
So this could be all good news for Aiden. This is such a great turn of events. What what we got a hearing this week on Wednesday for Aiden at 2 p.m. You're going to be here. What's going to happen there? What are you expecting at that hearing?
Who the hell knows? I mean, it changes by the day. Look, there was a motion, as you know, that was filed. I know there's been discussion of that motion being argued. I don't think that's accurate. They have a right to respond in writing, and they're entitled to that. So I don't think it will literally be argued. There are some aftershocks, I'll say, that you'll hear about in response to that motion in terms of other discovery issues which have come to light since the filing, which I assume will be addressed. There could be discussions of conflicts of interest, clearly, on both the 23 and 24 case that are addressed. And we'll go from there. But I think the primary thing that would happen is they're entitled to a schedule to respond to the motion. And then we get a date to argue it and go from there. But as far as the 2024 indictment, the issue becomes you have to prosecute or dismiss. We can't have a case without prosecutors, which is where we're going to be come Wednesday.
Yeah, that's a good question.
So there comes a point where a case that is a living, breathing prosecution must receive oxygen and continue, right? And as it stands right now, that's a decision that somebody on the other side of the table will have to decide. But the question is, who the hell is going to decide it? Because as I said, there are no prosecutors. The district attorney
conflicted.
Absolutely is in no position to decide it. So ultimately, what's going to happen?
Could he recuse himself and send it to another DA? Is that possible, or is that still a problematic issue?
Well, I don't want to suggest where it would go or what could happen, but it would be absolutely inappropriate for the Norfolk DA to put fingerprints on this one way or the other, because it could give rise to an appearance that whomever they select, what's the motive there? Why are you picking them? Are they going to help you? Are they going to torch the witness? Or are they trying to get, again, there's an appearance. This is the macro problem with Norfolk County. Okay. And this is kind of the larger issue that, people like me, whether involved in a particular case or just a talking head, have talked about the crisis that exists in this county. And this is the poster child of that crisis. Okay. They have spent hundreds of thousands of dollars on 3 special prosecutors, one of whom is going to be a witness and got kicked off the case, 2 of whom rightly recognize they should get off the case. And again, that's no disrespect to them. That's the right move. And it's just cost extreme taxpayer expense. One questions why perhaps some of these people were hired in the first place, with their record, and to what end? Here we are. These are indictments that are, going on, they're from early 2024. So they're almost 2 years old, the 2024 indictments, and they're going to be basically floating there with nothing. They're not going to be a living, breathing prosecution, and they're going to have to the court is going to have to figure out how to handle this and who is the appropriate person to even get somebody to attempt to resurrect this. Of course,
the AG doesn't want it.
There are public filings talking about the AG's position. I'll just leave it at that.
Yeah, she definitely doesn't want it. I reading between the redactions, because it's hard to. That's a problem when we're reading these documents. It's all the redactions, but she definitely. I don't think she wants to touch this.
The AG emails are not redacted because those were released in a Freedom of Information Act request. The DA released those themselves. So whatever emails you're talking about, the Attorney General, are in the public realm that have nothing to do with any protective order.
So we know that she doesn't want to touch this. That's the bottom line on.
as I said, there's information in the public record. It speaks for itself. It's publicly available. People can draw their own conclusions, but
Yeah.
they haven't done anything, have they?
No. And they're not gonna. I mean, that's the thing. Who would want to be a special prosecutor now? Like after all this crap, like who's gonna want to? Yeah. I mean, will Cosgrove even be there on Wednesday?
No.
He will
Yeah.
be, right? He'll be there. He's got to finish it through here, right?
Well, I mean, there is a mechanism to this. You need court permission, and he follows the rules of the court. I mean, he's a judge. He knows procedure. He notified us as he's supposed to, and of course he'll appear and he'll state his reasons for seeking a withdrawal. It will be granted, and then we'll have to deal with the 2023 case, which is not the subject of whatever you saw reported or whatever the publicly filed motion for withdrawal was.
Going to be interesting on Wednesday. See what happens. How long this lasts. It's
the three-ring circus does come to Norfolk County a lot. It more often than probably it should.
Everyone. That's the other headline right there, Lisa. Mark will be here. He'll be here on Wednesday in person, Norfolk County. So I hope people show up. It's 2:00, right? 2:00 on Wednesday.
Right.
I've had that on my calendar for a while. It's like we're all waiting for this next hearing. So that's Aiden Carney. And today there was the civil hearing for Karen Reed. Did you watched all of that, didn't you? You did, right?
I did.
Type up something about it.
I mean, there's a lot to take away, but never bury the lead, right? I mean, there's 10 different threads of this and that, and what do you think about this? But the lead from what happened today is they are going to sue the Alberts, the McCabe's, the usual suspects from the state police and whatnot, and they're going to be dragged into this, whatever this is, whether that be as third party, dragged in as third parties into the existing claim, or whether they are forced to be independent defendants in a second claim. I mean, that seems to be a question of contention amongst the court and parties. But again, that's all semantics. They're all getting sued. So again, never bury the lead. The McCabe's, the Alberts, Proctor, Tully, Buchanan, Higgins, I think they mentioned, they're all going to be dragged into this. They're all going to be deposed. And, that changes a lot of things. That certainly alters the case against the civil case where Karen is a defendant. And I mean, I'm not going to be intellectually dishonest. This is a major, major development to the 2023 indictment against Aiden. These are, well, most of them anyway, are the alleged victims of the witness intimidation who are getting sued for conspiracy to violate civil rights and are going to get deposed and be dragged into this. And it's just the reality. It's not a good development for the prosecutors in the case against Aiden. And it's not a good development for the civil plaintiffs in the existing case, on behalf of the O'Keefes.
Now, does it make a difference with what you said, whether that they file a separate suit or they bring them in on this suit? Like, what's the plus or minus? Is there anything that is better for Karen to do it one way or the other?
Yes. I mean, there's two reasons that would favor it. I mean, the first is judicial economy. I mean, who the hell wants to have two large lawsuits going on with different dates, different this, different that? So, I mean, that's probably their strongest argument for the court to agree to do this. Sorry, hold on. Would be to get judicial economy. But the other advantage for Karen, if they're joined in, would be, I mean, if you're the civil defendant and being accused, as you heard the plaintiff's lawyer, rant and rave about today, I'm sure we'll talk about that in a minute, about his bizarre response to a motion to dismiss. But if you're the civil defendant, you want that jury who's there to, adjudicate you to see these people and hear all of that at the same time, right?
Yes.
I mean, so it's definitely a tactical edge for Karen's team to have them part of the same lawsuit, and it's cheaper, it's better for everyone on that level. But if they weren't part of the same lawsuit, they're still going to be able to, make their arguments. I don't think at the end of the day, I don't know that any of this is going to matter. And it's not because of today, which was the motion to dismiss, which is worth talking about. But a motion to dismiss is, the law is never set up to grant those. I mean, the idea is, have they pled facts, which, if taken as true, would meet the elements of a claim? That's all you have to do to survive a motion to dismiss. And if you can't do that, then, this is a lawsuit that has no legs. Even if you accept that the O'Keefe lawsuit is going to get past that threshold, they have another problem. You can't hold a woman liable for wrongful death if she didn't cause the death. And there has to be evidence of a death. And the evidence of the death, by the way, is not a plaintiff's lawyer ranting and raving and whining and repeating himself 7 times that she knows she did it and she left him for dead. And, that's all great for the press and, the audience watching, but that's not evidence. That's bluster, right? That's not going to impress the jury. That was a dog and pony show and whatever. I get it. It doesn't offend me as much as it perhaps offends some of the other people. I thought it was a little silly, especially when you heard it for the 5th time. But that, in order to hold her liable, you're going to have to prove that she did something. And it's a much less standard. It's not proof beyond a reasonable doubt. It's preponderance of the evidence. That's a much lower standard.
Yeah.
But all you have to do is go back to Karen's criminal trials, particularly the second trial, and say, even though she had no burden of proof in that case, if you said, where do you come out on which side of the table about whether there was any proof of she caused an impact or not, and you factor in all the evidence, and from the plaintiff's side, again, the plaintiff's side, not the prosecution, the plaintiffs, you'd say, well, they're going to introduce evidence that there's 40 something pieces of taillight. Okay. They're going to introduce evidence that apparently Karen was running around saying, I hit him, or did I hit him? Okay. Now, mind you, some of that evidence is coming from Jen McCabe, and, take that for what it's worth and all that. But then you go, that's all evidence that has credibility problems, right? How reliable are those witnesses? Do they have a motive to fabricate? Mind you, if it's Jennifer McCabe and she's being sued for conspiracy to violate civil rights by helping frame Karen, that's going to color a jury's view of her along with everything else. On the other side of the table, you say, how many medical doctors testified at the trial? 3 or 4? Every single one of them was consistent or certainly helpful with the concept of no impact. Then you had multiple engineers who were very consistent and helpful with no impact. In other words, what I'm saying is, even though at the criminal trial, Karen had no burden to prove anything other than create reasonable doubt, I would suggest to you at the trial that just ended a few months ago, they did in fact prove well beyond the preponderance of the evidence that there was no impact. And if that's the case, goodbye.
But it will take some time. Like you said, most cases don't get dismissed right away. You end up going to trial. She'll probably win this, it sounds like. But
the case won't get fully dismissed. There are certain claims which probably should. Look, the law, they were arguing about, well, they shouldn't be able to sue for infliction of emotional distress because, we can all agree that the O'Keefes suffered emotional distress, whether it's Karen's fault or not. Their loved one died, and, that's terrible. The problem is, anytime anyone dies in life, particularly in unnatural circumstances, family members are caused emotional distress. I mean, if your loved one dies tonight, you are going to suffer emotional distress. And in addition to saying it's somebody else's fault to warrant recovery, you have to be close in time, proximity, and location to the incident to be able to recover. So, if your loved one dies in a horrible car accident in California, and somebody calls you on the phone and says, "Oh my God, our relative got killed by a drunk driver," you can't sue for intentional or even negligent infliction of emotional distress. And the reason is because everybody would be allowed to sue for every single thing in the world. And the problem with this case, and this is no disrespect to the O'Keefes, they didn't witness what happened. They weren't there. They weren't close in proximity. The theory of the case is that John O'Keefe died at 12:30 or close to it. And so that's the argument that the defense is making and the plaintiffs are arguing. And I thought the most interesting part of that argument was, the plaintiff's lawyer made, he went real all in on these arguments, very emotional, very aggressive. And what you saw, and this is a very effective legal argument, when, he was up there way too long, he was way too whiny. I understand he was playing to the press and the audience. That's all right. Lawyers do that.
He wants to get some more business.
But you saw, well, whatever. You saw a very effective, though, response, which was short, sweet, to the point, which is how you're supposed to do it, because the point is you remember it. I don't remember what this guy was saying.
Exactly.
But I remember what the defense was saying, and he pointed out the guy citing this case, Chimino or something, and he's talking about how you can recover, even if you're not in close proximity. And he said, but in that case, the plaintiff was in the car of the relative who was killed in the drunk accident. He did witness it. He did feel it. He did observe it. He did see the horrible circumstances. And I thought that he really discredited the plaintiff's dog and pony show with just those 30 seconds. That was very effective counter argument. But, that's what it's about. So whether the judge dismisses a few claims or not, the whole case is not going to get dismissed on that.
Now, we were talking about the countersuit part of it. How likely do you think the judge, because the judge seemed a little bit like, this is already too big and we're going to add all these counter complaints. It's going to be dragged on for years and years and years. To me, that shows maybe he has a little reluctance to do that. Does he have to allow them to countersue? Like, how does that work? Does he decide it? Like,
yeah,
how does it work? Yeah.
It's all up to him, but I think really it's going to come down to how effective Karen's lawyers' papers are, how persuasive. I mean, the more that they can establish that the facts do overlap, not just by making a 5-minute argument, but by saying why bringing in these third-party defendants, it's the same set of facts, it's the same issues. Judges love judicial economy. And that is a very compelling argument. Rather than have two
trials,
lawsuits, go back and forth with this and that, if you're able to mush it into one pile, then it ought to be done unless there are reasons not to do it. The facts don't overlap. If it's too prejudicial, whatever. But the reality is, the argument that I would assume Karen's people are going to make are judicial economy, number one. And number two, it's critical to our defense that the jury let us or see us put forth our defense, which is these people are responsible, not us. And the argument that I expect they would make is that our argument of a defense is much weaker if we can't put those people on the stand and show the jury they're responsible, not us. So notwithstanding the back and forth, I would not be at all surprised if ultimately the judge allows it. Not that he wants to. Nobody wants like super litigation with 8,000 people in the courtroom and this and that. But ultimately, it may make sense. But I think you have to wait and see what the papers that they file are. I mean, they pretty much preach them, but you have to wait and see.
You're gonna wait and see. One thing I thought was very interesting We got a comment here. Judge O'Shea is a great judge.
I
This
thought
was
he
the
was.
first time we saw like a hearing for Karen Reed start like a minute or two early. Like usually when Bev, it was like foul or late every single time. It was never on time. This guy started like a minute or two early. I was kind of shocked. I was
all,
like, holy shit.
all, all lawyers ever want in litigation is a judge who is fair, even temperament, briefed on the issues, willing to listen, respectful. And again, they'll rule against you a lot. I mean, that's how litigation works. I thought the judge today was fine. And certainly for people who've been watching, the Karen Reed saga for, 2.5 to 3 years, from their perspective, I imagine it was a welcome just sense of a breath of fresh air, I would imagine, for them.
I mean, people were worried Bev was going to pop out of the wedding cake or something. Like she was going to take over this one too. Like,
I don't think so.
I, uh, this guy seems like even keeled. He seems like he can handle it. He's not going to get. I didn't
He
see
seemed
any like
good.
getting angry or anything. He's just like,
No,
let's get it done. Let's move forward.
no, he seemed like a professional judge, which is, again, that's all you can ask for as a litigant. That's all you can ask for is a judge who is judicious. This man was judicious.
Definitely. He also the one part I thought was kind of silly, but I get why he's doing it because this is what talking about settling. Um, do you
There
think
is no
there's
chance.
no chance Karen's going to settle this, right?
No.
Or even the bars? What about the bars themselves?
So, you should never say there's no chance of a settlement
Yeah.
because, the judge is right. All we're talking about is money here. Nobody's going to jail. No one's doing this. But the idea that Karen is going to settle, especially when you hear the theory of the plaintiff's case and the way she got, raked in the mud today. No, I mean, I would expect her to fight to the death and frankly win. The bars probably have a very strong defense, but I can tell you, I would assume their counsel would be, the word I would use is pragmatic, which is we don't really give a shit. Okay. And if we have to cut a small check that is 20% of what it would be, even if we win through billable hours and years of litigation, I'd rather, throw money at them and just leave now. I would not be at all surprised if they did that, even if they have valid defenses. But the idea of Karen settling, you never say never, but I would be stunned out of my mind if she settles. And let's be honest, she's suing. Okay. You're not settling.
You're fighting back.
Admitting,
Yeah.
or even if you're not admitting anything, if your intent, and which they publicly announced, by the way, that's a bold thing without actually filing the lawsuit.
Yeah, and naming names too.
And names. So no, they're not settling. They didn't look. I'm sure Alan is very happy with Massachusetts culture and loves it there, but I don't think he's hanging out in Massachusetts to settle. He's hanging out to litigate.
Like someone just said, Jackson ain't there to settle. That's true. I don't think so. He likes, yeah.
He's not in this case. I would be stunned. But again, we're not privy to what's going on. But no, I certain cases have to be tried. This is probably one of them.
Definitely. Yeah, you were talking about the plaintiff's lawyer.
Mm-hmm.
Some of the statements he made today. I mean, he was bringing up Turtle Boy an awful lot. I just thought that was funny because he's acting like Karen controls Turtle Boy and all this stuff.
I listen. I didn't expect the plaintiff's lawyer to have Turtle Boy derangement syndrome. That was.
He did. He had TDS. Definitely. That's a good. Yeah, that's a good observation. He definitely had TDS.
I mean, look, I understand a lot of people really don't like him. I get it, but if that's what's on your brain in this lawsuit, you've probably already lost. In all seriousness, he has nothing to do with a wrongful death action that the O'Keefes are bringing against Karen. Okay. Now, again, that was not part of the motion argument. That was just gratuitous dog and pony show for the audience and whatnot. Whatever. But, constantly saying that, he's steering the ship at her behest and this and that, that's just pure media fodder.
It's crazy too, because it made it sound like all of us too, like not just Turtle Boy. Like, he named some of the other outlets and stuff, but it made it seem like we were all following the orders of Karen Reed, who I've never talked to. Like, so how am I following her orders if we never talked to her? It's just
guy's a lawyer.
Crazy.
He has a job to do. He's clearly intelligent. That's all fine. He's a good lawyer, but respectfully, sir, you're way off base when you're turning this into the Karen and Aiden show is why we're here. The reality is you can pursue any claim you want, which they are, but whatever you think of Turtle Boy or don't isn't going to help you establish by a preponderance of the evidence that Karen Reed ran over John O'Keefe. And if you can't do that, you lose. Like, that's it. It's really that simple.
You think this guy's crazy enough to bring up Aiden Carney as a witness on this? He's going to depose him?
I don't know what the legal basis would be. Again, how that impacts a wrongful death. I mean, look, I'm not going to sit here and talk this guy's strategy.
Yep.
I would be much more concerned with finding witnesses that are going to help me establish by a preponderance of the evidence that there is some kind of impact, and how we're going to contradict the ARCA witnesses, the medical witnesses, Russell, La Posada, Scory Bento, I forget her name already, the medical examiner. I mean, you're going to see the same witnesses that you saw at the criminal trial. I mean, the issues are a little different, but you can't just wish away the evidence that came out at the criminal trial. And the bottom line is there's no credible evidence that, the taillight shattered naturally. And again, this is why it's so important about whether the judge allows the countersuits, okay? Because like Proctor will be one of those. And the plaintiff is going to be screaming up and down and saying that those taillight pieces show a collision. And if the defense, the civil defense, is able to establish, yeah, that's the third-party defendant dirtbag who got terminated and fired for having bias against her and is being sued for violating her civil rights by planting the evidence, amongst other things, like calling her this and calling her that, you can see the whole dynamic of the case changes.
Had a question, which I want to kind of piggyback off of about the witnesses too. He says, will they bring back Judd? And I just wonder, will they bring back like all those special, expert witnesses that cost a lot of money? Like I can't imagine the O'Keefes are going to pay for like, $500,000 for these people to show up. How does that work? Would they even consider that?
The defense is going to bring back all of them because they were great witnesses.
Yeah.
But do the O'Keefes want to spend $1 million, $500,000 to bring back Judd Welcher? Well, let me ask you.
Exactly.
Let me ask you a different question. If it cost a penny, would you bring him back?
No,
I wouldn't.
It's not worth it.
So
not worth it.
Forget.
I mean, ARCA's different.
Judd Welcher was an embarrassment. He was just lipstick on a pig. Okay, he took the state police evidence, if you will, and just had a better resume. But of course, a lot of the information that he relied upon was from his fraudulent companion, Shannon, whatever his name was,
Burgess.
With the terrible and allegedly fake academic credentials. No,
he's about to graduate this year, I heard. June.
I mean, I don't even know what to say about that. But I mean, to me, it's not the cost of bringing back Aperture. It's why would you? But again, this is the problem. So you either bring them back or you find someone else. But you're going to have to deal with it's not just the ARCA witnesses, it's the ARCA witnesses and the medical testimony. That is like a firewall, okay? That is an impenetrable firewall that the plaintiffs almost certainly are never going to get through. Every credible medical and engineering person with experience in this is going to tell you that in our expert opinion, there's no evidence to suggest an impact. So how is the jury going to get there? Forget beyond a reasonable doubt. How are they even going to get there by a preponderance? It's not going to happen.
I wonder who they could actually have as a witness. Like, how is the plaintiff going to actually put on a case here? Like you said, they put up Proctor. Like, that would. Who else? I mean, who can they put up there that would actually be a good witness for the plaintiff on this?
Not Michael Proctor. That's for sure.
Yeah. Who? I'm trying to think. Like, I can't think of anybody that would be like, oh, maybe if they just put a couple people, it might confuse the jury. I don't know how they lead on this.
They're going to be
the medical examiner. I don't know.
The best moments that they'll have at this trial will be sympathy witnesses, the children.
That's right.
Anybody's going to feel terrible for those children, but that only goes so far because they don't really establish much, legally speaking. So this lawsuit, I mean, we talked about this before, I'm sure this lawsuit appears fundamentally flawed on its face. And that's got nothing to do with the motion to dismiss. I'm talking the long game of this. It just appears destined to crash and burn.
There's another great witness that the defense will probably bring up, Officer Barrows.
And not only will he, again, support the defense position, but he will also testify, presumably what he said during his YouTube interview or whatever that was, how, in essence, I tried to share this with the DA's office and they didn't want to hear it. They didn't even ask me. And how do you think a jury's going to like that when they see all these people are being sued for civil rights violations? And how do you think the jury's going to feel about Buchanan and the inverted video? And I mean, you could go on and on and on. This is destined to crash and burn.
Good question. Instead of like even bringing them in, can they use their previous work even on the plaintiff side too? I say prosecute.
No, they're going to
plaintiffs.
No, they're going to have to test.
They got to have people come in.
Besides, if you're the defense, you want that. You're not.
Yeah.
Listen, they had 27 lawyers in the courtroom today. It felt like, obviously Alan came back for this. They're going full bore. They didn't do this to half-ass the production of evidence, as a civil defendant. They're going to go full bore, as they should.
Going to be interesting to see when this actually happens, because
it'll be a long.
This judge is saying 2027.
It's going to be a long time.
I wonder about Turtle Boy too, because his cases might all be done. I'm thinking they should be done by 2027. What do you think this will be the end this year for Turtle Boy, or do you think it's going to go on to next year too? If you had to put, I know you can't really say, but I'm just wondering how long is this going to last for him? I feel bad. He needs a break.
I don't think any of the cases against him are viable. I think certainly one in particular at this point has become untenable for a lot of reasons. It's a case where there's just no credible witnesses, and that goes back then, and that also includes recent things that you've perhaps seen, just in the public realm or online recently. Beyond that, I won't say anything, but let's just say we're very confident that this is going to end the way it should be, which is, this never belonged in a criminal court, irrespective of people's personal feelings about him or not. This is not what these statutes are intended for. witness intimidation, and it's a Massachusetts problem. Witness intimidation in most states is offering somebody a bag of money to change their testimony, or taking a baseball bat and threatening to break kneecaps or harm your family if you don't do this. Witness intimidation is generally not where a journalist, even an aggressive one, even in a very unique manner, is firing questions and accusing you of being complicit in something based upon publicly filed court documents by lawyers in the case. That's not what these statutes were designed for. And it's time that these statutes just stop being weaponized for that purpose.
This one right here is a good question. In a civil trial, can the feds be mentioned?
Sure.
Yeah.
Why not?
Yeah. They should have been mentioned before. Just the
Well,
judge made a dumb ruling on it.
They were. Look, you can nitpick about how that trial was handled, but the door was blown so wide open on the feds in Karen's second trial that there comes a point where a judge should say, look, it's out there. I'm just going to instruct the jury on, what it means, but playing the games that they were playing at the end of the trial by chastising lawyers for mentioning the word agent or whatever, the toothpaste can't go back in the tube. That was silly.
Good. I'm glad. I think that will make it easier for the jury to know what's actually going on. Karen asks, what does Mark think about them trying to get Karen again on witness intimidation? It seems like Karen and Aiden actually maybe on I don't know. Are they actually doing that, or is that just threatening? What do you think?
I don't want to comment on what, and speak for them, what they're doing. I'm certainly aware of what's been in public filings, and perhaps am aware of things that are not in public filings, as you might imagine. I would only say this. As a matter of common sense, and you would have to be crazy if you try post-acquittal to indict Karen Reed and Aiden Carney for witness intimidation, put them at a table together, whether it's the little closet courtroom or the big courtroom, and put all of us lawyers there together, bring Alan, bring Karen's other lawyers, bring myself, bring Tim, let us all
Together.
Party together, call the witnesses, the usual witnesses from the McCabe's, the Alberts, whatever, and allow 2 rounds of cross-examination, not one.
Yeah. Bederow, Bradel, and then Karen's. Oh, that would be awesome. That would be the best for us YouTubers. We'd love it.
Based upon alleged witness intimidation of people who testified in a murder trial where the defendant literally sitting at the table was acquitted. That would seem,
and everyone knows. Yeah, it's like world famous acquitted. Like not just like acquitted, nobody knows. Everybody knows it. Like
that is to me the worst use, if this were to happen, the worst use of prosecutorial discretion and common sense I could ever imagine. And the only thing I could expect is that all the people that are, into free Karen Reed and free Turtle Boy and all that stuff, the exponential growth and outrage, I imagine, would grow 5 times within a week. And, they've made a lot of really poor decisions that have, in my view, embarrassed themselves nationally. I wrote about some of this. Like the rubber duckies is a perfect example. That was just a national embarrassment. The idea that, in particular, Karen, frankly, that they would try to throw her at the table for alleged witness intimidation on a case in which she was acquitted. And, obviously the jury didn't find the testimony of the people that they allegedly intimidated compelling, with everything else you see going on. with all these other problems would be just the worst use of prosecutorial resources with 0% chance of success. But, they have the power, so you have to just wait it out and see where it goes. But I'd like to think that ultimately it'll never happen, just for the reason that whatever you think about them, that there comes a point where common sense takes over. Maybe you hose yourself down, let the emotions subside, and say, maybe what we ought to do is get the hell out of here and just be done with Karen Reed. They lost. They didn't get her. They're never going to get her. Let it go. The taxpayers deserve better. And which is another question. The controversy of wasting more taxpayer money to get an alleged witness intimidator on acquitted cases as opposed to anything else in that county. I mean, it's just in my view, an irresponsible use of public dollars with no chance of success.
Enough is enough. How much do they want to spend on this? It just keeps going up. The bill keeps going up.
Yep. Until it happens, I don't believe it's going to happen.
Yeah. It seems like they're just trying to screw with them more than anything, isn't it? It's like,
I don't want to say any more than that. Until it happens,
I
just don't believe. I mean, look, all the lawyers involved, I mean, we're all ex-prosecutors. I mean, I was a prosecutor,
right.
Tim was a prosecutor, Alan was a prosecutor.
Eddie was.
David was a prosecutor.
Yep.
So, we have the ability to kind of, live in their shoes with real experience, and just, the idea that this would be the right thing to do is so 180 degrees the opposite of the right thing to do, that it would just be mind-blowing if they literally took that path. It would be stunning, to the point where I truly can't believe that they would do it. So we'll have to wait and see.
I know, it's funny because they're crazy. That's the thing. That's why we don't know if they might actually do it, because they're so crazy. I mean, that's
one of the things and this is another Massachusetts thing. In Massachusetts, you get a no true bill in the grand jury, you just try again. I mean, this is insane. You can literally, without leave of court, just try again. I mean, and you could never do that in New York. You'd have to argue to a judge and explain newly discovered evidence, this, that, and it basically can't happen. A grand jury is supposed to be a check on the government's power, and if they say no dice, it ought to be over. But in Massachusetts, they just say, and
I'm back again.
Oh, and the crazy thing is, we need to look at these phones. Those phones have been in their custody for how long?
Years.
Why are you doing this now?
Yeah.
Now, you had no interest in pursuing this with the phones? When you had Mello try to indict them the first time? That was a Mello and Tully production as well, by the way. But yeah. So the point is, now you need to get into the phones to pursue that. I mean, this just reeks of bad faith, and it reeks of a criminal justice system that needs to rein itself in.
Definitely.
The idea that they can go back to a grand jury, and it's not newly discovered evidence. It's evidence that they negligently sat on for years and have now decided, well, we got to get her for something. So, that's my view anyway.
It's a question here. Hose Ravenson, are depositions televised or released after the civil trial is over? We never get to see any depositions.
Well, depositions are not like YouTube events. Let's be clear. No. They are done in a lawyer's office.
That's right.
They are often videotaped, and they get used during the case, but they don't become, YouTube productions or presentations.
Is there any way we can get that guy from Belmont, his video? That would be so entertaining.
the federal depositions are very frequently recorded, video recorded. Sometimes they are in state court, depending on how much you want to pay for whatnot. As the litigation goes forward, they may get filed in court filings. They may get used in court, and they become public that way.
Oh,
But they're not live events. They're in a lawyer's office with a court reporter and the lawyers and the witness.
so we could actually get some copies of some different depositions, possibly videos, not live events, but later on.
Yeah, I mean, you've seen some of that online, and like historically and famous cases. Every now and then you see depositions. Yeah, I mean, not always, but you can.
Because I want to see the guy from Belmont. I guess he got deposed. I'm hearing not related to you. It was the other one.
He got noticed.
The civil case.
He got noticed for next week, I guess.
Yeah, that would be entertaining. Oh man, it would just be funny. It would just.
What I mean, what do you even say? I mean,
Yeah. Endless comedy. I wonder how he's got to come up with a print fund. I don't know. He's got a lot of printing to do. It's going to be expensive. I'm laughing at the comments now. Anything else that we didn't talk about, especially I guess like on this lawyer today, going on and on and on and on, kind of playing to the camera. Anything else you want to add on that specifically, or anything else?
No, I mean, he's a lawyer advocating for his client. I thought it was repetitive. I thought the tone for a motion to dismiss was whiny. The references to JJ and Turtle Boy and whatnot, he was veering off course, but I get it. I mean, he's being a lawyer, he's being a zealous advocate. I thought when he said we had no idea that we were going to be told today that these people were getting sued. I mean, that may be literally true in the sense that like they were not formally told we're going to do this, but I don't think anybody with a straight face really believes that they didn't know this was coming. So, that seemed to be a little faux indignation, but whatever, that's part of the game too, I suppose. I just thought his argument for the motion to dismiss was 90% emotion and shrill rather than, fact-based, but I also understand why he did it.
Came up. Is there any difference for jury selection, civil versus criminal? Will people be disqualified from serving if they heard about the criminal case verdict?
Well, it's very different. The number of jurors is different. I don't know about Massachusetts civil practice, but jury selection could be, a couple hours instead of several days. It's different. The legal issues for service are very similar. I mean, if somebody has a potential bias or can't be fair and impartial, then, just because it's a civil case, they shouldn't serve. So you still have to weed out the bias and all of that, but civil jury selection is a lot less sophisticated than criminal jury selection. Civil trials just, you're not protecting somebody's right to due process. You're protecting everybody's right to either get paid or be the one who pays, and that's just not as serious.
To answer this one, it's kind of an interesting question. Karen says, I thought you can't be arrested in your own home. I don't know how. LTL had videos of Karen's arrest, and they arrested her inside her home. Is it because they had a warrant for her arrest?
Well,
they can arrest you anywhere, right? I mean, what?
I think Karen answered her own question. You can arrest someone inside their home if you have an arrest warrant. I mean, that's the famous case of Payton versus New York, which was a U.S. Supreme Court case where it talked about warrantless arrests in somebody's home, and they made a warrantless arrest and then found evidence in plain view or something like that, and the evidence had to be suppressed because it was an illegal arrest. But if you have an arrest warrant, you can, and of course, anytime you get consent, it doesn't matter. So even if they, and again, did they have an arrest? I didn't watch Brian's show. I didn't watch the video. I mean, body camera video of the arrest at this point, whatever, it is what it is. But, if they were to knock on the door and Karen opened the door and let them in, well, there goes your need for an arrest warrant. Like, you've been given consent to come in. So, but generally, if you lock the door and they say, open up, it's the police, and you say, they need a warrant. They can't break your door down unless there's an exigent circumstance. If there's,
See you run inside with a kid that's been kidnapped or something.
Absolutely.
They can charge
Right.
in and break in, try to save the kid.
Fourth Amendment goes on hiatus if there is a true exigency. You can't hide and lock the door and say, I'm allowed to kill someone now because you come in here. But you can't just go in under normal circumstances or general suspicion, even if you have probable cause, without an arrest warrant.
When I was in my 20s and partying, we had the cops show up one night, and I was like, turn off the light. We turned off the lights. We didn't answer the door, and they went away.
We know our rights.
We know our rights. Just be quiet, people.
Knew their rights. See, that's good.
That's right. Turn down the music. Lucky I was looking out the window. I was like Matt McCabe looking out the window. Saw him pull up.
I'm sure you saw a lot more than Matt McCabe looking out the window.
We were starting to play that again, Matt McCabe's testimony today, to refresh. It was fun. Full melt hash value says, can ARCA be hired? I'm not really sure about it. I think they're asking if can ARCA be brought back, right?
I think they're saying
the
jury learned that ARCA was hired by the FBI. The answer is going to be yes. This is going to be central.
Oh, that's what the question. Oh, yes. Yeah, okay. I'm
central.
glad you translated that for me. I was a little confused by it. It could have meant, yeah.
This is going to be.
Yeah, we kind of answered that earlier, right?
This is going to be central to Karen's defense. I didn't do this, and guess what? The feds knew it. I mean, that's the argument they're going to make.
Going to be that should be very convincing, actually.
That's pretty
Feds
powerful.
hired these guys, and they.
I would. That's going to be pretty powerful stuff. Absolutely, that these guys were hired not by us, but by the federal government, and that's what happened. Yeah, that's all. The rules of evidence are going to be a little different here.
JJ stuff. I feel this comment. I know it probably really doesn't make any difference legality wise or court wise, but it just seems kind of strange.
It doesn't matter legally. It is a little weird. I would simply say this. I understand family. The lawyers shouldn't be doing this. Okay.
Right.
The lawyer should be calling him John O'Keefe or Mr. O'Keefe or John. The lawyer in a motion to dismiss shouldn't be being colloquial. I mean, that's a jury pitch. It sounded a little contrived in making a legal argument if that's ostensibly what he was doing, which it's really not what he was doing. He was preaching to the public. But I would think that most lawyers, at least in arguing to the court, would call him Mr. O'Keefe or John.
Think we'll see her again? The civil case, possibly? Will they bring her out? The defense, maybe.
That's a very interesting question because, on the one hand, she's a disaster and a train wreck. And if you call her, what is she going to do? Say, you're right, I lied at Karen's trial? Not likely. On the other hand, you'll get out the evidence that she did, in fact, tell the FBI that she saw some pretty crazy stuff. Now, I would suggest to you this. If Dever, which one is? I think it's Dever.
I don't know. We say both just to get her mad.
Whatever.
Maybe she'll call in some night.
No, I'm not even trying to be rude. I think it's Dever. If she is going to be a defense witness this time, what I would imagine the defense would do this time is build a much bigger foundation leading up to that. And by that, I mean laying out long before she ever steps into the courtroom, the layout of the Canton Police Department, where the monitors are, what it looks like, where the Sally port is, and make it crystal clear before she ever sets foot in the courtroom that there's no mistake here. You're looking at the monitor, like you can't miss it. You know, I mean, which tells you they may not have fully known they were calling her until they did, because they never really laid that high amount of foundation. So that might be a tell, you know, at the civil trial, depending on the level of detail about the layout, including pictures from inside the Canton Police showing that she had a clear view of those monitors. And when she tells you, I can't remember, give me a break.
Why did you resign? I mean, that'd be another good question to ask her.
You know,
I'm surprised she did resign. Like, what? Who gives up a job knowing that you're probably not going to get hired for another job, right? I mean,
because the reality is, look, you know, Google's forever, right? The internet's forever, and you see that testimony she gave, and it's disgraceful. I mean, it was childish, it was petulant, it was dishonest, it was emotionally inappropriate. I mean, it was just, I mean, it was so weird. And I just, you know, you can't police if that's how you are. And I think she realized that. It's kind of sad. But on the other hand, you know, these are we've talked about this before. She made those choices. You know, she came to Bad Choice Road, as we talked about,
yeah.
Breaking Bad reference or Better Call Saul reference. And she made the wrong choice at Bad Choice Road and just continued to go down that path and ended up the way she did. So I think she had no choice. I mean, she's just not capable or credible to be a police officer, and probably not emotionally stable enough to have a loaded gun in split-second decisions. I mean, if that's how she acts on a witness stand, how is she acting in a fast-moving street scene where life and death is like that?
I know you compare her to someone like Barrows, like just night and day.
Yeah,
The demeanor, just the demeanor. Never mind what they said.
Yep.
Yeah, I know. It's funny. Some people say I have no sympathies. I really don't either, but I still do because she's a mom. I just feel a little bad, but she, like you said, she made the wrong choice.
Complicated, but at the end of the day, she has to look in the mirror. She made the choices.
Hopefully, she recognizes it. Maybe she tries to make up for it. That would be the best thing she could probably ever do.
It would be, but how do you know, look,
I know. How do you?
If she were to come clean now and just admit
what
she's going to say, I perjured myself.
I know.
In order to frame this innocent woman. I mean, think of the exposure you're subject. I mean, she's twisted into a knot, which is probably why false memory.
Yeah, false memory. Do you think we might see this guy lucky again too?
100%.
Yeah.
I mean, Karen is trying to establish I didn't do this. Lucky is a pretty important witness that's consistent with that. And also, if they're dragging in people from 34 Fairview, he becomes a very strong witness with regard to that too. You know, the car out there that wasn't there and the body that wasn't there. Well, how the hell did it get there? Yeah, I would expect you to see him.
Love it. I'm glad they're letting us televise this, that they're, you know, putting this on the air. So, because I felt like people weren't going to get to watch this, and it would just become like, you know, the craziness before when things weren't televised, when we're relying on Grant Smith Ellis, and it's so much better when people can watch it, know what's going on.
Yeah, no, I mean, you shine a light. The best way to shine a light is throw it out there, let people watch, gavel to gavel, and draw their own conclusions. That's all you can do. And then some people are going to think A, some people are going to think B, but you know, at least you have it out there, and you're not relying, like you said, on like not credible half a journalist or whatever he is. Yeah, that just draw your own conclusions and don't be stuck to people's tweeting of what's happening.
You think the feds will ever allow cameras in? It seemed like they were doing a couple like pilots, not like on criminal cases, but some other courts they have. But
I mean, federal court's pretty, belt and suspenders, very stodgy, very strict. It's a different culture. It's a different animal altogether. I doubt it. I mean, I just think it's so the antithesis of federal practice to the idea. I mean, probably they should, right?
yeah,
Uh, get audio in the Supreme Court of the U.S. and whatnot, but I don't think you're going to see full fledged video in federal court anytime soon.
mm,
I mean, we try to walk in the Southern District of New York, and even with your special ID, you're limited how many devices you can bring in unless you're on trial and you get a judge's signature. And the next thing you know, if you're bringing your iPhone, I'm taking off my Apple Watch, and that's the lawyers. I mean, that's how tight the security can be
mm.
in some of these federal courthouses. But, well, I mean, New York, obviously, terrorism and all that. But so the idea of video strikes me as probably not anytime soon.
Do that to the attorneys. That seems crazy. They're
That's
making you take off your Apple Watch. Come on.
that. Well, no, it's take your pick. You get one,
Yeah,
and you're going
you
to take
get
your.
one device.
So there goes the iPad. There goes the Apple Watch. Unless you get, an order from a judge on a certain case to say, let this guy have his computer. Yeah, no, it's very strict. It's very strict.
Overly strict. It's just
Well, obviously the Southern District of New York is a few blocks from the World Trade Center. It's a little sensitive
that's
down there.
right. Of course. I mean, that's some of the biggest cases too, like the terrorism cases.
Yeah.
And
In the old days, the biggest terrorism cases were in the Southern District of New York, and some of them were in the Eastern District of Virginia, which is basically Washington,
DC.
but or close to Washington. But that, I mean, obviously the Southern District of New York is where um, most of that stuff occurs.
Perfect. We've been talking a lot about the Kelsey Fitz Simmons case too. Nothing really new has happened. I don't know if you have any further comments because I know you came on the show and talked about it
Yeah,
recently.
I mean, I'm not. I haven't seen anything. I haven't talked about it with anybody since we listened to that god awful
The judge.
bail hearing, which was disturbing. But I don't know that much about the facts, other than some of the red flags we talked about. But I'm not in the weeds, so I'm not even that familiar with any of the facts.
What's
But
going on?
just the bail hearing, I thought was yikes. That was bad.
Yeah, absolutely. People have been asking about that too. Tomorrow they were supposed to have a family probate hearing. I think that's either being rescheduled or they're doing it without people showing up. I'm not sure. So
I'm
it's
not sure.
not being advertised for people who are asking in the chat. Um, yeah, so I think we covered everything. It's been an hour and 15 minutes. I'm just wondering if there's anything else that we didn't bring up that people are looking for questions to be answered or anything you have, Mark, that you think is important that we
No,
didn't talk about tonight.
no, I'm not here to advocate. I don't have a speech. I mean, if you want to throw up some questions, that's fine. But I mean, I have nothing to pitch.
Oh, I mean, this question, I always assume it's funny because I assume people know what's going on. I don't do a lot of introduction because I feel like people just know what's going on with this Karen Reed stuff. The question for definitely David Gregory says, so who's suing who? Is Karen Reed suing anybody?
Not
I mean,
yet,
that, yeah,
but soon. The O'Keefes are suing Karen Reed and the Waterfall and CF McCarthy's, and Karen has indicated her intent to drag in as third-party defendants. I think she said Brian Albert, Nicole Albert, Matt McCabe, Jen McCabe, Brian Higgins, Proctor, Buchanan, Tully, and I guess the Canton Police and the State Police. I think that covers it. But yeah, so she wants to bring 10 more defendants to the party.
people are asking me about Kelly Deaver and her kid. I don't know. I don't know where I heard that. Just, I don't know. I don't know why that keeps coming up tonight. It's a weird thing to.
Ah,
I don't even know if I'm right. I could be wrong. I thought I was right on that, but
I don't know, but I mean,
it keeps coming up. People are like really obsessed about that. I don't know why.
I hope her and the kid are okay if that's the case.
Yeah. I probably heard it from one of the Canton people because the Canton people are like, they're all into. They know everybody.
I don't know.
Yeah.
Who
I
cares?
don't
I mean,
know either. It
not
doesn't really matter. It's funny that people get so like that question kept coming up tonight. I was like, I don't know. Here's a good question. Seth says, are the plaintiffs able to get access to the Fed's stuff? They said they were still waiting on DA to hand over stuff.
they did say that they're waiting for discovery. There is that federal protective order, which in theory, the DA is supposed to light a match to everything in T minus however many days. Some of the stuff is in the public record, though, introduced as exhibits in court or whatnot. So either way, a lot of this is still going to come out. It's not like stuff that you've seen is going to disappear. The real question is, if there's more, is that ever going to come to light?
Because now the big thing is that they're correcting me saying that Kelly Diva doesn't have any kids. Okay. All right. There's important stuff tonight. We'll find out. We'll look it up for everybody. If I'm wrong, I'll put a retraction. I think that's it pretty much. There was probably I'm just going to see if we missed any other good questions here.
Question about typeface and font size.
Yeah, what about that?
No, come on.
That was interesting. You got a lot of pushback about crazy, stupid stuff. What was that about?
Nothing. That's normal. I don't know.
Yeah.
I don't know why that's a thing to certain internet keyboard warriors. I don't know.
Especially going after you for your writing. You're a good writer. Like it's obvious you're a good writer. You're a good speaker. Like it's funny when they go after your strengths. Like what? It's like
weird. I don't know. I mean, you have to laugh.
You do. It's like complaining like Tom Brady could have thrown more touchdowns. Like really? Is that?
I mean, look, the reality is that that's normal font and typeface. That's what people use when they write briefs.
Right.
And there are actually certain rules in certain courts, and that's what we use. And so why wouldn't you use the same thing? But apparently, you use that for 10 years, thousands of times. It's never a thing. But you file a motion in Massachusetts where a bunch of incels and Twitter trolls follow it religiously, and all of a sudden it becomes a scandal. It's crazy stuff.
Incels and Twitter trolls. Definitely some incels in that crowd. Music to my soul says, question, if you have another 10 parties involved, once it gets that complicated, can a jury decide that case, or does it have to be a bench trial at some point? That is the weird thing. Would it get so confusing having all these different parties involved?
No, I mean, if there's a jury trial, it's a jury trial. You can't just literally decide, I don't want this to be a jury trial because there's too many people here. So, no, if it gets complicated, it gets complicated. It is what it is. But, the whole case is complicated.
I mean, it is complicated, but in the end, it's really, did she hit him? Did she hit him? I mean, that's pretty simple in the end, like when you really come down to it. I don't know about the counter suits, like that might be more complicated on how you go after them, but
I mean, some of the other claims are a little more complicated, the emotional distress claims.
Right.
But in terms of, if she didn't hit him, then she's really not legally responsible. And if she didn't know that she hit him and had no reason to think that she hit him, then you really can't hold her liable for causing emotional distress intentionally or negligently by, yelling and running around and asking the child, what happened, or did I do this, or whatever it is. It does come down to whether she hit him or not. It's just a basic concept. And that's going to be the fundamental issue. And, the plaintiff's theory is that she had to know and she knew, and then she lied and did these terrible things. But, there's a reason why juries are instructed that opening statements and summations are not evidence. And what you saw today in the motion to dismiss argument, which, was very passionate. Again, you can't fault someone for advocating for their position, but that's why juries are told it's not evidence. It doesn't matter how many times you say it. It doesn't matter how emotional you say it. It doesn't matter how many times you pound the desk. Just repeating and repeating as a lawyer that she knew she did it, that's not evidence that she did it. You need evidence. And, what you heard today was not evidence. It's a theory.
I didn't even read it. I'm just posted up as soon as I see it. She got a question. Does Mr. Bederow think the defense will seek to move their case into federal court, given the judge's less than lukewarm reception of their desire to third party in the various parties?
It's an interesting question. There's all kinds of issues there. Certainly it sounds like they're going to raise some federal claims. One could say, why not just file in district court? I don't know what their thinking is, but, I'm sure that's something that they'd be thinking about. But also you have to factor in what are their goals here? If you go to federal court, you do lose the TV coverage. Do they want that? Is that something, I'm not saying that would be my primary concern, but, not being privy to those discussions, I'm not sure what their thought process would be, but I'm sure right now it's more just, do we even sue? Do we sue as bringing it into this case, or just file a new claim? If they do file new claims and they're talking about civil rights claims, which is what they said, then it seems to me I would do that in federal court. If they're third party defendant claims, I think it would be in this court.
Could the bars have liability for over-serving John if they contributed to his death from a fall or of some kind?
Well, I don't know how they're going to prove that. And, the issue is that they overserved Karen. The problem is, you've all seen the video of her drinking and all that, whatever. But all the witnesses that are not favorable to her, exactly. The McCabe's, the Alberts, the other people are going to say she seemed fine.
Yep.
And, she seemed no worse than we were. So
all the cops in the morning said the same thing.
Yeah. Now, on the other hand, there is a drunk driving conviction, and they will use that.
Sure.
The plaintiff will use that conviction as evidence.
Here's a good one. A Twitter lawyer said they didn't think AJ's strategy of announcing their intent to add 10 people was good. They should have filed first. What do you think on that one?
It depends on what you think their goal was. If their goal was just to put it out there and, throw a bomb and take the story, so to speak, for today, which they did. That's the lead, clearly.
That's the lead.
It could
That's what
be
I heard from everyone. All day you're like, right. That was the lead. That was not even from like what we were putting out there, just what everyone was talking about today.
And I think that's a short-sighted view, and we're not privy to what they're thinking, and it could be any number of things. It also could be this: you stick your finger in the wind, you throw it out there, they get their press hit, and they want to hear the reaction of the judge before they decide what to do. And you know what? The reaction of the judge was, well, I'm not crazy about this. Well, now they know before they file. Look.
That's a good point. I
Well,
think most of us don't realize that
no,
that
I, listen,
lawyers kind of will put
this is
things before the judge to see how he feels before
it's
they
it's
spend
easy
time on it, right?
it's easy to criticize. They should have done this. They should have done that. Um, but you also have to recognize we're not privy to those discussions. We don't know why it is they're taking a certain course. We don't know what goal they were attempting to do. We don't know if ultimately they are going to file in federal court or they wanted to hear what this judge was going to do. They wanted to hear how the defense reacted. They want to hear how these people react. There's so many different variables and moving parts that can go into this. And these are master strategists. So I wouldn't be so glib as to say, oh, they should have just done it and not told them. And then what? I mean, they gathered intel today. They know what the judge is concerned about. They're not giving away any secrets. Okay, if you don't think that the plaintiff's lawyer, who by the way looks to be a very good lawyer. Okay, when I'm saying I wasn't crazy about his argument, but I understand it. The guy's a good lawyer. Don't kid yourself. He clearly knows what he's doing. He clearly was prepared. He's clearly up to the task in the sense of the case they have, which I don't think is a good case, but whatever. He's a good lawyer. And they might have wanted to hear what he had to say. But the point is, he knew that these people are going to get dragged in. They haven't exactly been hiding this. So they didn't give away any state secrets. They didn't lose any leverage. If anything, what they did was they stole the
The
press coverage.
thunder.
Today's
Yeah,
hearing is
totally.
all getting sued. And guess what? They all are going to get sued. It's just a matter of when and where. So explain to me what leverage did they give away by, they should have just filed at risk of what? What have they lost? They haven't lost anything.
No, you're right. They would have spent
Intelligence,
time and
they
energy in something too, and not have that kind of intel,
so
like you said.
I don't
I,
agree with that.
yeah, and I agree. Like they led the day. Like that's what Hobby Carver's leading with today. The
What's that?
McAlberts are getting sued. That was the lead. Hobby is a guy that always looks for the lead. You know what I mean? So that was it. Like they won the narrative, no question about it. Um,
Yeah, I don't think they did anything, screwed it up or should have
no,
done this or that. I mean, if they had showed up and filed it, okay. But I think we're being hyper critical and hyper technical as if this matters. And I think the way they did it suits me fine. I think it's very tactical and maximizes all the intel that they gather, the news they get out, and to see how everyone reacts, and then they do it the way they're going to do it. So I thought it was fine.
a question from LS Visuals who wants to know what font did you use? Times New Roman?
No, no, no. Most people use Times New Century Schoolbook.
Century Schoolbook.
Century Schoolbook 14.
Is that a good font?
It's the best. It's what most lawyers who write heavy documents, appellate briefs, will use. And most courts actually, believe it or not, prefer 14, not 12. It's bigger, it's clearer, it's clean. And yes, double space, easier to read, fully justified, better presentation. That's, yeah. So, traditionally people used to use Times New Roman 12, which is very bland, boring.
Small. Hard to
Now,
read,
the
I
key is
think. My
Century
eyes.
Schoolbook 14 and many paragraphs. Break up the paragraphs. Nobody wants to see a page of running text.
There you go. Paragraphs always work.
Appeal to the reader. Keep them
Right.
interested.
Right. Um, this is a good question right here. And I'll just expand on it a little bit with Sue too. She says, could this be turned into a RICO trial? I just wonder, like, could this be turned into some type of criminal trial? Because a lot of times we see where civil suits get filed, the feds see something, some evidence come out. I think that's happened with P. Diddy. I mean, his case has started with Cassie suing him, and the evidence that came out, the feds decided to prosecute him on the federal level criminally. Could something like that happen here? Here?
I doubt it. I mean, who knows? I mean, if people testify in a way that's very incriminating, or it's obvious that they perjure themselves, stories change, people crack, you never know. But I wouldn't be optimistic generally without knowing more to expect that this is somehow going to turn into some kind of criminal case as it relates to, the mysterious death of John O'Keefe. I think the reality is that that's unlikely in my view. I just don't. I think it's unlikely. And, the irony is, and I'm sure we've talked about this before, is that anybody who were to even be investigated or prosecuted is going to use a third party culprit defense, and they're going to, defense is going to be Karen. And you know what? It might even work. It doesn't mean that she did it. She didn't. I mean, I think this, in my view, she got framed, no question. But, if there's a reasonable doubt analysis from another person, they're going to say, well, maybe she did say this and there was taillight. How do you know? I mean, they turn it on its head.
Totally. Yeah, and after 2 trials, I imagine there's not that much new probably going to come out of this.
You never know. And, if something does happen, then, they ought to do it. But I mean, if you were asking me as a betting person, I don't think it'll ever happen. I mean, could be wrong, but I doubt it.
I doubt it too. I doubt Bederow is going to be wrong on this one. Laura doesn't the first bar she was at have a better chance at a dismissal than the Waterfall because she just started to drink there. They were not the ones who overserved.
I mean, that's a fine argument. But the second bar is going to say, well, I don't know what she had before, and she appeared sober. So, I mean, look, again, I don't think any of this is particularly, great. Now, are they, whoa, but she left with the glass from the first place into the second. That doesn't mean anybody saw it. But at the end of the day, if you can't establish an impact between SUV and pedestrian, what are we doing here?
Sharon D says, since Turtle Boy was brought up today, do you think you'll need to participate in the civil trial? Do you see yourself getting brought into this somehow?
Come on. Look, that was bizarre and worth a chuckle only because it felt like Turtle Boy derangement syndrome. They obviously want to blame him for everything. I get it. I understand they want to blame him for, publishing autopsy photos and this and that. And by the way, that can be very upsetting. And, I think we all can agree, but he's coming at it from a journalist side. Okay. And working on a story. And, do you think a reporter from the New York Times, if they get a story and they get a big scoop on a huge case, is going to say, well, I can't publish it because, it might upset people who think differently? I mean, there are only a few rare exceptions. I mean, obviously, victims of sexual abuse, their names generally don't come out, certainly not by the media. Unless they're already public or put out. But the idea that a reporter is going to avert his eyes to evidence that may shed a lot of important light on this is important. And, the reality is this, and you saw some of this in the motion, it's publicly filed. I'm not editorializing, I'm just stating timeline facts. There was a motion filed on April 12th of 2023 that was publicly filed in a court of law that was over 90 pages of sworn allegations of fact supported by documentation, including cell phone extractions and other evidence. And in that motion, it was alleged that essentially the people who are now all the alleged victims in the 2023 indictment were somehow complicit or knew what happened. And that was publicly filed in a court document that a journalist found and then based reporting on that. And that upset, understandably so, by the way, that upset the people who said, oh my God, they're reporting that we're involved in this. I would be upset too. We would all be upset. But you can't blame a journalist for doing what journalists do. They report news. And if you go to court files and pull things and report it, that's what the towel does all the time, right? He lives on the docket, right? Doesn't he like live in like the hallway of the courthouse looking for filings and then, puts his spin on it? That's what real reporters do too. It's upsetting. And then it becomes a big story and it becomes more upsetting. I get it. But that's not a reason to drag a reporter into a wrongful death lawsuit for reporting facts that may be offensive. They may be, in your view, distasteful. They may be upsetting. But, why this turns into, somehow he's in any way responsible for this, whatever you think of him, it's just not accurate. And to somehow make the argument that Karen is responsible for that as well, and that somehow is intentional infliction of emotional distress, that argument fails because the lawyer is, he's making conclusions without evidence, and he said, she knew. Okay. The flaw in his argument today is that you have to accept his premise that she did it and she knew. And therefore, if she did it and she knew and helped publish all this information, well, that's terrible. But what if the evidence is she's innocent, is being falsely accused, and is on trial for her life and is trying to get it out there to prove to the world? Well, there's the flaw in his argument. All of a sudden, any information that gets out publicly, you have a different view. Somebody's fighting for their life to get the truth out, as opposed to, I know I did it like you say, and I'm just trying to harm someone else because I don't care. And that's the fundamental flaw in the plaintiff's argument, is they can say it till the cows come home that she knew, but you can't prove it.
Right. Hard to prove.
Yeah. Well, it's hard to prove because there's no real evidence of it.
Right. Big Old Dog has a question. Can federal judge strip DA of immunity in 1983 suit like they can with the cops?
There are ways to get around the generally almost absolute immunity the prosecutors have. They have to be involved in the investigation as opposed to the prosecution, which is a different, like that's a lawyer function. Investigative is like a police function. Now, you could make the argument that the prosecutors were involved in the investigation. They were at the autopsy, doing things pre-indictment. I mean, you could make a real argument that they were. Another way you can sometimes sue the DA is through negligent supervision as it relates to training and just negligence in disclosing evidence. And, I wondered if that was going to be a part of this. Apparently not. But again, they make the judgment. I thought after there was a hearing a couple of months ago, whatever it was, on that other case, that King case where Lally testified in a way which was just shocking beyond belief.
Awful.
His level of just, I don't give a shit and indifferent was just stunning to me as a former prosecutor and lawyer. I mean, I've never seen just the shocking indifference to your ethical obligations that perhaps
trial too
was indicative of a lack of training and supervision and best practices and whatnot. But, again, these people know what they're doing and they're going in a different way. And rather than, I guess, make the tough argument, which may not hold up, I think they're going for the low hanging fruit and, the fat turkeys, so to speak, and, just bring them in and go from there.
Chris Thompson. Have you ever met him?
Who's that?
Hunter S. Thompson. Have you ever met him? No.
Which Thompson?
Hunter S. Thompson.
Oh, no, I've never met Hunter.
No. Yeah. He wrote some good books. I like the Fear and Loathing on the Campaign Trail. That was my favorite. Yeah, politics one.
Yeah, no,
I like that one. Which one? You want read some of them? You must have read all of them, I bet.
I'm not a big Hunter S. Thompson guy, actually.
Yeah.
Yeah.
Now they're giving us other quotes. William Wallace. You may take our lives, but you'll never take our freedom. Did you like that movie? What was that movie with Mel Gibson? Braveheart. Do you like that one? That was good.
I mean, many years ago, I got this crazy idea. What are the 100 greatest movies ever? And they had like the official, AMI list or whatever it is, whatever the American Institute, whatever it is. And it took me like maybe 3 years, but I watched all of them. And now I'd already seen like probably 60 of them, right? Like right off the bat. But I actually went and watched every single movie in not that I don't know why I'm telling you this, because Braveheart sure as hell was not a top 100 movie of all time. And I'm not a big Mel Gibson fan for a lot of reasons, but yeah, I mean, it was okay.
I'm not a big Mel Gibson fan for a lot of reasons either. That's a good. I'm glad you said that. You're saving me. I might get some crap from the family if you hadn't said thank you, Mr. Bederow. I forgot. I'm just reading what they tell me to post here, like Goodfellas, and they also brought up Miss Doubtfire tonight.
Well, Goodfellas. Well, I made a Goodfellas joke the other day. I posted a picture of my two dogs staring in the other direction, like, this one goes.
Oh, that was funny. That was a great picture. I saw that. Yeah, they were.
Ma, I gotta borrow this night. Gotta hack off the hoof. What do you call that paw thing? The hoof. Yeah.
The hoof. The claw. Oh man.
Great movie. Goodfellas.
The Godfather. I know you like The Godfather. Did you like every single one of them though?
No, Godfather 3 is garbage. Godfather 2 is probably the best sequel ever because it's every bit as good as the first one, which is virtually impossible because the sequel never is, but yet The Godfather was so good. But the whole origin story and the flashbacks and toggling on and off between De Niro and Pacino is amazing.
We'll do this question. Sharon D says, Mark, didn't Brennan already try with Cosgrove to get Karen and Turtle Boy communications from her phone? I thought it was a day when Karen and her lawyers walked, not knowing it was happening.
Yeah, they tried to do stuff, although those were not, I believe, from her phones. That was the other direction.
All right. Godfather 2 was the best.
It's a good movie. It's Hyman Roth, right? I mean, that's where a lot of the funny lines come from. Every time lawyers complain or get stressed out about tough things, you say, this is the business that we've chosen. We're going to be bigger than US, right? I mean, you could go on and on with these quotes.
Oh, yeah, I remember binging Godfather series back when VHS. Remember VHS?
Of course.
Do people even remember VHS? I know we do.
But I mean,
kids today, do they even know what a VHS? These kids today?
No, The Godfather is one of those movies where if you're on regular TV or like YouTube TV or whatever, and it comes on, the remote goes down, and it could be
sit there for a while.
I mean, it could be 5 hours by the time, because they're going to follow with Godfather Part 2. And then when Godfather 3 comes on, you can, you leave.
Then you turn it off.
Terrible movie.
It's like Rocky 5.
Ugh, never should have been made. But you can't.
Yeah, I think the second movies, it's funny because like a lot of rock bands, the second album is like they never match up to the first
You,
big album. But I
you,
feel like movies, a lot of times, the second movie is better. Like Empire Strikes Back is probably the best,
that's
you know,
true.
or Revenge of the Jedi wasn't, it kind of went down a little bit. It's like,
The
yeah,
best Star Wars movie. Is actually
second one.
Rogue One is the best Star Wars. The one from like maybe 10 years ago.
Oh,
The,
Rogue One, see, I never saw that one.
that's the one that's in between the two where they steal the plans.
Mm.
But the problem with Godfather 3, and then I'll shut up about movies, is you took these like two incredible movies with these just incredible characters, and then you get the idea that, you know, the main character, or one of them anyway, in Godfather 3 is going to be the bastard child of Sonny Corleone. I mean, really? That just doesn't fit as like a main character thread for me, given
Didn't
what
work.
yeah.
Yeah, where it came from.
Yeah.
We kind of answered this, Brett, but maybe Mark wants to answer a little more in depth. What is your impression of the defense attorney today in the civil hearing?
Karen's attorney, good. Yeah, no, I mean, fine. You know, to the point, perfectly demeanored, I thought. In particular, I liked his response to the very long argument. You know, he poked a hole in the lawyer's citing of the case and just drew a big distinction that he left out. Thought it was effective. You know, there really wasn't that much to do other than say, we're thinking about suing everyone. We're just figuring out how to do it. And as far as the motion to dismiss, you know, they filed briefs. The briefs are going to speak for themselves. Made a few points and did what you call hit and move on. I thought it was fine.
Me too. He looked good. The other guy, like you said, I felt like he was going on and on about Turtle Boy and all this other crap. It was just like, come on.
I think he got carried away, but don't mistake that for not a good lawyer. I get the impression he's a very good lawyer. Actually, I took away that he's been doing this. He does it well, knows what he's doing. I don't think he has a great case. I think he's got the tough part of this. He's going against an army. I think he's going against people that have the facts on their side, but I would not underestimate the plaintiff's lawyer. I think he did, he seems on top of the case, as they said.
Perfect. I want to thank you, Attorney Mark Bederow. You've been answering all the questions tonight. I think we're pretty much all questioned out. I don't see many more questions tonight. I think we answered them all. We're starting to repeat the same questions. This one always asks. This is one that always comes up now. They want to know if you're going to run. You're not giving up what you love to do, right?
No, I'm not. Look, I'm not running for office in Massachusetts, but at this point, I should probably write the check and get admitted. It would probably make a hell of a lot more sense.
Massachusetts, yeah, why not? Seriously.
It would be easier at this point just to do that rather than this Pro Hawks.
Yeah. Because, I mean, I guarantee you, there's so many people who want to hire you in Massachusetts, so.
It's a lot of travel.
If they could just go direct, that would be easy. They don't have to have another lawyer to do it.
I'm not moving there, so a lot of travel.
You could take the what do you do? Do you take the train or you take the what do you call that? The shuttle?
I go all kinds of ways.
Drive. Or you drive, yeah.
This trip I'm taking the Excella.
Okay.
I've done it any number of ways. I've flown, although I haven't flown for this yet. It's a very short flight, but it's either usually drive or Excella.
Yeah. I like driving, even though it takes so long. I'm such a control freak. I don't know why. I get like putting my life in someone else's hands, even though when you're on the road, you're driving, the other cars could hit you anyway. So
the problem is, and yeah, I mean, I like driving and I drive all the time, but you've got the traffic on the back end. The New York traffic is terrible, and by the time you get,
Oh, yeah.
the Massachusetts rush hour, it's just like, God, this is.
Oh, I've done it. When I was at AIG, our like regional office was in New Jersey. Wow, what the hell is the name of that? Morristown. So
Mhm.
I used to do that drive a lot, and it's just like,
Yeah, no, it's
you know how it is. You hit the Connecticut, and then you hit. It's
one of
just
the
like nonstop traffic.
one of the weirdest traffic things in the world is Stamford, Connecticut.
That's right. Yeah.
It's like 20 miles north of New York. It's a satellite city. A lot of firms have offices
Oh yeah.
in
WWE was
WWE.
that's where they
There's
were at for
a
years.
lot a lot of companies have the back office in Stamford. So it's a
Right.
sizable city. It's not far from Bridgeport, which is kind of a big city. And it doesn't matter, but for some reason, whatever time of day on the 95 corridor, it always slogs in
Always.
Stamford. I don't know why. It's not that big.
Yeah.
Always.
I know that ride. Yeah, always.
It'd be worse than the
I'm so glad
crosswalk.
I don't have to do that anymore.
I mean, it could be worse than, 95 in the Bronx, which is absolute hell, usually.
Train sounds fun. I like the idea of Excella. That sounds fun actually.
It's
That would
only fun if you take the Excella and you get a real seat.
gotta
Otherwise,
have
it's
a seat.
not fun. Like a reserve seat.
Yeah.
Otherwise,
So that's the
it
key. That's the key. Get the
and
reserve seat.
and an Excella, it doesn't stop at every station on the way. I mean, an Excella, from Penn Station is going to stop in Stamford, maybe New Haven, Providence, and then, once you get to Massachusetts, basically. The other trains will stop. Oh my God, every town, every.
It's brutal. That's what
Yeah,
I don't like.
yeah,
Too many stops.
yep.
Like even subways, it's kind of annoying. It
Uh,
depends. Subways aren't bad, but it's when they stop for like 10 minutes at the stop. It's like, all right, we stopped, keep going. Like, you know what I mean? Like that's what used to kill me about the MBTA. It's just like the 10-minute stops on a subway train. It's like,
well,
come on.
the subway in, well, the T, whatever, is very different. It definitely stops more. It waits. People are nice. New York, the doors are open for 10 seconds and you're in or out. They crush you, and you either get crushed in or shoved out, and on you go.
I
It's
like that.
they run
Get in there, get out.
they run 24 hours. They're nonstop, and it's also very interesting because whenever I go on the T, people talk, and they talk loud, and they talk in normal voice and have regular conversations. That never happens on the New York subway. The rule of the New York subway is shut up. You just,
Silence.
you just,
Yeah.
I mean, it's just a cultural difference. Like, nobody's talking loud. And if you were, you'd be getting the looks and the whack in the head and all that. But when you're in the T, there can be these people having full volume, you know, talking about what they're doing in Brookline later. It's very different.
Cultural difference, Boston, New York.
Yeah.
Um,
It,
this question kept coming up, and I'm glad it came up one more time because this will probably be our last question tonight. Is it possible that Hank gets appointed to be the special prosecutor for Turtle Boy's case?
appointed by who? Appointed by
I
who?
know, right? Morrissey can't do it, right?
Appointed
He's
by who?
conflicted.
Um, how would the taxpayers feel about that? Are there other conflicts? Um, this is not a realistic scenario.
Do you think even Hank Brennan even wants to do it? I think Hank Brennan's like, I'm done. I'm done. That was
But
never.
I wouldn't speak for what's in his mind.
Yeah, I know.
I don't know. I mean, I have my own feelings about him, as you know, but in terms of, I wouldn't even pretend to guess what he would do or wouldn't do. But I don't think it is a realistic thing. So don't hold your breath.
It looks like if you were Turtle Boy right now, you'd be feeling a little happier. Is that the general consensus? You think? Will be safe to say that?
Well, I mean, you're still charged with a number of crimes, so you never want to get overconfident. Nobody wants to be a criminal defendant, but I don't think it's surprising that the cracks are starting to appear and spread and things are happening. I mean, we've never felt that this is a good use of resources, a viable case, one that's likely to result in a conviction. Again, you don't arrest people because you don't like them or you don't like what they're saying or to silence them or because you think they're obnoxious, whatever it is. And that's what appears to be happening here. And, we just go where they send us. So if the cases continue, we fight. If they go away, great. You can do it the hard way, right? The easy
hard
way.
The easy way. I love that.
The easy way is they dismiss or they implode. The hard way is we just sharpen up our elbows and punch our way out of the corner and fight to the death. If that's what it is, not our choice. We just go where they send us. And so we'll do it the hard way, the easy way. It's not our choice.
Excellent. I want to thank you, Mark, for being here again tonight. And we'll be watching you in court on Wednesday. I'm looking forward to it.
Yeah, we'll be there. It'll be fun. All right. Thanks for having me.
Thank you. Have a great night.
You too. Bye.
Attorney Mark Bederow. I want to thank him for being here. That was good. Someone said, same with me. I'm a control freak. I drive to Mass from Connecticut. I know, right? My girlfriend, like anytime we go to somewhere together, she just knows I'm driving. Because I am a little control freak like that. Miss Smith says, Mark, is it possible for Hank to be appointed as special prosecutor for Turbo's case? We did ask that. All right, perfect. All right. I'm going to read a couple super chats that came in. Scooter 54, been a member for 14 months, says Bederow for President of the United States 2028. I don't think he's going to run. Poe's Raven said, thanks for a fabulous show, guys. Good night. Good night, Poe. Kat Randall said, did Mr. Bederow ever meet Hunter S. Thompson? We did ask that question. Thank you. A few people were asking that in the chat. Sandy Jeans, can they deny to testify if on lawsuit? Not sure on that one. Gifted 10 Young Jerks memberships. If they're subpoenaed, no, they have to testify. Thank you so much, Sarah. One of our mods gifted 10 Young Jerks memberships. Mama She 13, been a member for 7 months, says living it up in Lambda Bederow era. Thank you so much, Mama She. A couple more. Glamassus, Aiden's deposition when Gaffney sued him was great. Oh yes, we need some video. We're gonna get some good. I think we're gonna get some good deposition videos. Ms. Holmes 66 sent $2 and said, Mike, you were cracking me up tonight. Slap happy. I am a little slap happy tonight. I took a little nap. I got a call earlier today and they were telling me what was going on with Howie Carr. And I said, I took a nap. And the person was like, I wish I could have taken a nap today. And I said, yeah, I took a nap for once. It felt really good. Tara said, because I knew I was going to be late with Bederow, so needed some energy. Tara said $9.99. Thank you so much, Tara. Beautiful Messy Ball sent $1.99. Said there were rubber ducks, turtles all over CrimeCon. I know, right? That's funny, actually. Legal Onlooker sent $4.99. Said when they win, can they recover any court costs from the O'Keefes? They can try. Not likely, but it's possible. Kat Randall said gifted 1 Young Jerks membership. Amber says Bederow makes us feel better. Thanks, Mike. Sui Generous says, love you too, Mike. Thanks for always being a great journalist and being the original Bederow show. Thank you so much, Sue E. Generous. Tony becomes a YouTube member. And True Crime Kangaroo just renewed the membership, says member for 12 months. A year. Great show again. Thank you. Thank you for being here for a year. I think that's awesome that this is your 1 year anniversary of being a member here. And I got to say, I did see a couple comments that were trying to make sport of me tonight. I just put you on, I don't even know what you call it, where, what's it called? User in timeout. I don't come here to be made sportive. So some of you come out of the woodwork. I hope you enjoy your timeout. I am slap happy jerk tonight. Glenn, I'll never put you in timeout. Glenn makes me laugh. And he even, he throws the knife in a little bit, which is fine. It's fun. But some of you are just not nice. Some of you are just like complaining. That's the thing. You'll never see Glenn complain. Glenn will throw the knife in me. He's not complaining. Excuse me, now I'm coughing. Music by To My Soul just gave us a donation. It says, Mike, I caught some of the footage of you hosting Grace's show the other day. I thought you did a great job. I think I did okay. I'm pretty sure they're inviting me back. They said they would have some more dates for me soon. I don't know. I think I could do a lot better. I get very nervous, I gotta say. Having a time frame where I know I have to be off of in like 10 minutes, and it just it's different. It is a different jam. And then you're working for somebody. You know, 10 years ago, I went self-employed, and I said I'd never want to go back and work for someone, and I'm kind of working for someone now, but it's fun. I mean, it's not like real work, but at the same time, when you go in there, I do get a little nervous because it is someone else's place, someone else's show. You wanna do the best you can, but it's fun. I enjoy it, and I like the challenge of doing something that I feel like I probably couldn't handle before. I'm not really supposed to be a radio host, folks. I know people think I do a good job at it, but I am not. Look, I mean, when you listen to like Taylor Colmier, her real fill-in co-host over there, her producer, he's got that smooth radio voice. It's easy for them. Doing it here on the Young Jerks is pretty easy for me. But it's different when you go into a studio like that. It is just different. But I do enjoy it. And yeah, I think the best thing I like about it is how much you guys like it. It's like I can tell people go nuts on those show days. I feel it back. I'm like, wow, people are really enjoying these shows. I'm not disparaging myself, Glenn. I'm just being honest. I know my strengths and limitations. I'm pretty damn good at a lot of shit. I know that. I'm not selling myself short. I'm just honest. We are getting Money Mike and Brother Council show soon. Maybe. I could have invited him tonight. I should have, but it was late. I definitely would like to do a Brother Council Bederow show. That would be fun. He was really good on that, Brother Council. I like him. You only watch when I'm on? I only watch Howie when Turtle Boy is on also. I know that feel. I mean, oh, thank you. I thought it was great how you used the time to highlight really important issue. I try to do my best. Oh, you want an angry Mike? That's a good idea. How do I? It's weird though, because I would have to get angry. Like it's sometimes I do get fired up over here. Yeah, well, we will have to get an angry Mike icon. We'll have to do something. I do enjoy doing it, Caroline. But I will say those are long days. Like for me, I want to be there early. So it's like it's only 12 to 2. It's only 2 hours show. But I leave usually about 9, and I usually get home like, 3:34. So it's kind of a long day for a 2 hour show too, I must admit. But I enjoy it. I do. It's fun. I don't think I could do it every day like other people do it. like Grace, 5 days a week, I'd have to live a lot closer. Ah, you want the angry Mike? Everyone's looking for angry Mike in the. We'll see what we can do in the chat. Ah, think about my lawsuit. I know, right? Ah, don't get me going. Don't get me going. Oh, thank you so much. Another super chat, Miss Holmes. Thank you so much. She says you make us jerks very proud. Oh, thank you so much. It's spicy Mike. I know. Maybe that's what we need a spicy Mike. I mean, I say it's a long day, but you allegedly maybe it's not actually that long. I mean, you should consider some of the dog walk days that we do when we're dog sitting. Sometimes I'm starting at 7 in the morning and ending at 11 p.m. at night. You know, some of those long days. I don't do that to myself like I used to. Have too many customers and just be around the clock 24/7. That's the way I did my dog walk business and my dog sitting business for a number of years. And so like long days in radio and doing this and it doesn't even compare to other businesses that are just literally you wake up and you go to work and you work until you can't stand up anymore and then you go to bed and you wake up and you go back to work. Not like that. Someone was complaining about my mic again tonight, saying it goes in and out. I know I have had been this mic is pretty expensive too. It's weird because like it has not been the best mic. I have this great mic over here, but it's got to be plugged into the it's a really nice mic actually. It's got to be plugged into the studio equipment, and I stopped using the studio equipment because there were issues with that. So I may end up getting another new mic. We'll see. I try to do my best over here with the mic, but it's I don't know. I don't know what the problem with this mic is. You'd think it would be good. Yeah, I do. That's what she said. I go in and out. Thank you, Glenn. Fucking guy. I'm out of here. I'm done. No, I'm actually. You know what I'm gonna do, Glenn? Sarah's laughing. Fucking Glenn. I didn't come here to be made sport of, Glenn. Fucking Glenn. Oh man. But you know what I'm gonna do? I want to play a little video. I figure why don't we just play the video again? I want to play this video from today. It's late. I just want to watch it again with my headphones on. I'm gonna go in and out. I'm gonna hit the bathroom, come back, and listen to it with my headphones. I want to watch this hearing again from today. It's not the mic, Mike. What is it then? What is it? Me? Are you telling me it's me? Am I breaking up? Like, what is it then? Let me speed this up a little bit so they get to the volume where the volume goes on. Actually maybe that is maybe I do move too much. That's probably the issue is that I do move too much. See, before I had the arm microphone where I could bring it to me, you know, and now I got this tabletop mic. Maybe that is the issue. Maybe I need to figure out the arm again. Okay, nothing's breaking up. So maybe I'm just listening to a bunch of babies who are crying, and there is nothing wrong, like Em says. Okay, my mic is fine. See? Okay. All right. Karen looked great today. I don't know if people noticed this, but it looked like It looks like Karen's more well rested. I don't. Maybe it's just me thinking that. Maybe it's the lighting's better here. But I just felt like when I was seeing Karen today, I felt like she looked more like less stress in her face. You know what I'm saying? And I don't know if it was other people noticed that, but I felt like that today. I felt like she, this is part of her like payback tour. You know what I mean? This is like Return of the Jedi time. It's not over, but the tables are turned.
All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA.
See you back in a few. We're going to replay this.
Case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well. Thank you.
Good afternoon, Your Honor. Attorney Mark Bederow on behalf of the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Kevel on behalf of Karen Reed.
Try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing, and that was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor.
Right.
So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant, and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay. All right. Procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that I'd issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point. including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed. Regardless of how the court decides those, we still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Dillard can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff order extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed-to extension? Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but there are a lot of records, as I understand it, that are still to be produced so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from C.F. McCarthy, then.
Your Honor, in a similar vote as to Waterfall, we were putting the finishing touches on our discovery responses. The last leg of it is just collecting communications from employees related to the incident, some of whom no longer work for C.F. McCarthy's, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then, in terms of the response to the procedural issue that was raised, in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would expect
Not how the court
that-
system likes this stuff to work, folks.
Right, I would expect the courtesy of the meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right, any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. When you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach, and we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it, and then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct?
Yes,
There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think, basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case, but to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying affirmative. You said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But you have 2 depositions, for example, of parties in 2 separate cases, where we can have one and the claims could proceed at the same time. Just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these 2 cases and throw it as far wide-ranging as they've just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
Okay. All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is no, the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here, if for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. And we rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants, if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can. The Waterfall?
Yes, Your Honor. On behalf of Waterfall, just very briefly, I think the distinction here that counsel's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't, from a relational standpoint, close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. would seem to suggest that, that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss?
No, Your Honor.
No? Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely. You know,
allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving two young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. and Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness. At or around 6 a.m., they rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has 2 components for damages. It has 2 buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings 2 separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, Argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute, and that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court, and I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident, because, as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenged conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendants should have known would result in distress to the O'Keefe family. To the extent that the defendants suggest that this case sits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases they cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident. Gets up, runs to see his son. It's contemporaneous. It's at the time of the event. And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. You also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint, and again, for the record, so that people understand this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint, and the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to assign a trial date, we could do so. I mean, literally, I've talked to the clerk, we could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties, and there's relatively novel theories as I'm hearing it. But nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say.
Just wanted to, we're going to play the end of this, but I just wanted to make a couple notes, programming notes. Number one, Thursday night, we're going to have a retired judge, a Massachusetts judge on the show Thursday night. I think it's at 6 p.m. to discuss Kelsey Fitz Simmons. So check that out on Thursday night. I do have some info, some news about Kelsey, what's going on tomorrow. People were asking about it tonight. People wanted to know if the hearing's happening tomorrow. And I know that Melanie Little did announce, so I think most people know that there isn't really going to be a hearing tomorrow. The family probate court hearing has really, it's, you know, the only thing, the lawyers are going to show up tomorrow, just the lawyers without Kelsey, to continue it to another date. She hasn't had enough time to prepare, so that's what's happening tomorrow. So people, October 7th, if you want to show up for Kelsey, October 7th, Essex Superior Court in Salem, Massachusetts. Be there October 7th, 9 a.m. And Thursday night, we're going to have a live show here with a retired judge talking about the other judge, what she did in the Kelsey Fitz Simmons hearing. Be here Thursday night for that. Wednesday also, Turtle Boy hearing at 2 p.m. A lot of people will be there live at the courthouse. Bederow, of course, will be streaming it. Looking forward to that. I also wanted to thank, we did have a Venmo come in. Let's make sure we thank the Venmo. From Barbara. Barbara M sent $20 on Venmo. Thank you so much, Barbara M, for sending the Venmo. And we also had Give, Send, Go donation tonight came in. I want to thank Joanne as well. A bunch of new donations from Maz's show the other night came in. Dalen Smith sent $10 as well tonight on the Give, Send, Go, the Young Jerks Defense Fund that we have set up right now. It's pinned at the top of the chat. All right, let's watch the rest of this.
That being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it, and ultimately a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here, clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench that's been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still, it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make ultimately. They're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do whatever.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay.
Preference, Your Honor.
All right, we'll do it in person. Fine, we'll do it down in Plymouth. I will be moving into the Brockton Court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure.
How many days out you want to go? 60 days, 90 days?
Yeah, probably 60 days.
60 days? November 21st, Friday in the end of November.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly, as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery, and any motions, Rule 15 motions to amend, or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor.
All rise.
Nothing with the jury?
The next hearing.
I don't think so.
Nothing with the jury?
See everyone. Definitely Wednesday, Turtle Boy hearing. And Thursday night, gonna have a guest on the show, retired judge, talking about the Kelsey Fitz Simmons, the latest hearing. Also gonna have some more guests this week. Stay tuned. Be checking us out every night. Thank you so much, jerks. I'll see you soon.